All rise. Court of Appeal in the 4th, 5th District of the State of Florida is now in session. The Honorable RVLJ, Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, everyone. It is our privilege to be here. This is the first sitting of the 1st District in Nassau County, Florida. So it is an auspicious occasion, and we feel very fortunate to be part of it. Especially so, as some of you may know, we're all Jacksonville residents, so we're part of the 4th Circuit, which envelops Nassau County, so that makes it even more special for us. Let me start by saying thank you to Nassau County, thank you to the citizens of Nassau County, the Bar Association, the Robert Foster Inn of Court. You have made our time very special here. Also, the members of the bench who were kind enough to show us hospitality this morning, that is greatly appreciated. We have 4 oral arguments today. Shortly, we will get to those. As I understand the protocol, we will have the first 2 oral arguments, take a short break in between the first 2 and the last 2, and then reconvene after that short break for the remaining 2 oral arguments. I am most privileged to have 2 wonderful colleagues here with me today, both recently appointed by Governor DeSantis to the 5th District Court of Appeal. Let me start with Judge Sapp. He is a young commodity here in Nassau County, having sat here for 2 years in 2015 and 16. And as I was looking at the bio for his time here, it said Judge Sapp presided over civil, probate, guardianship, juvenile, domestic violence, and family law. And I said, that sounds like everything but felony, Judge Sapp. He said, well, I did felony too. So that's everything. So he was here for 2 years at this wonderful courthouse, serving as a circuit judge here, doing everything. So I know many of you may know of him. He was a 14-year circuit judge before he was appointed to the District Court of Appeal. And as a former trial lawyer, he did many important things. I am the former trial lawyer, but the most impressive may be that he tried almost 200 cases, jury trials, as a circuit judge. Wow, that's a lot of jury trials. So I'm very proud and privileged to have Judge Sapp with me today. I also have Judge McIver with us. As I said before, recently appointed to the 5th District. I would commend his bio to you because he's done so many things I can't recite all in the short time we have available. But it's a snippet of those that multiplicity of service, very important state roles here in the state of Florida. Chairman of the Florida Gaming Control Commission, General Counsel to the Florida Department of Financial Services, Deputy General Counsel first to Governor Scott, and then Deputy General Counsel to Governor DeSantis. And of all those very important tasks, maybe to me, the most important, he was our Chief Administrative Judge for all the administrative judges in the state of Florida. What a big job. Wow. Again, so I am very to serve with these two wonderful colleagues today. I also, not that I want to call him out and embarrassing, but I have my excellent law clerk here, Shane McGrath, who is a Nassau County resident, and I feel I'm very fortunate to have him. Thank you, Shane, for being a part of this, for being a part of this process. So, we will now call the first case, and the first case that I see on the docket is Friedrich versus the state of Florida. The council will come forward. Counsel for the appellant, you may come to the podium. And for the purpose of the timekeeping, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 5 minutes for rebuttal.
So noted. You may proceed.
May it please the court, and I echo your statements. This is an amazing courtroom, and I'm privileged to be here. My name is Michael Minardi, and I represent Larry Friedrich. When he started and when this case occurred, he was a 64-year-old man who had been running his business in 1992. In November of 2018, before the federal farm bill passed and created the hemp laws that we have today, he was engaged in selling hemp flower and other hemp products at that time. Now, what happened in this case is law enforcement went in there and they raided him. Their testing equipment at that time only showed 4% of THC, so they couldn't differentiate between hemp products and illegal marijuana products. The issue in this case, and the main question that I really have for this court in determining this, that I could never get an answer from the lower court, was, in this case, the officer, the detective, acknowledged that CBD products were legal since 2015. But yet hemp products and this hemp flower that Mr. Friedrich had was not legal.
Let's talk about that.
Yes, sir.
We may. As I understand it, hemp falls within the definition of cannabis. Would you agree with that?
That is correct.
And cannabis, at the time your client was selling the hemp, was something that was deemed to be illegal in the state of Florida.
So I would disagree with that. Cannabis was, but hemp was not.
Well, show me the statute where hemp is excluded out of what is criminalized in Florida.
So at that point in time, it was not necessarily excluded out, but for the fact that we had Florida Statute 1004.4473, which was our 2017 incorporation of the federal farm bill.
And thank you for bringing that up. But was your client part of the 1004 program? The pilot program for industrial hemp?
So I would say yes. And the question is this, is what does that mean? That pilot program only regulated and licensed cultivators in the state of Florida. It did not acknowledge or state anything about sales. It said that these hemp pilot programs could sell and could provide commercial activities of these products. He was not part of that program. He was not a cultivator. He was a retail seller of products that were authorized under that same federal farm bill that the state created that 2017 1004 Florida hemp bill based on. That federal farm bill, and this is really the interplay between the two different statutes, the federal farm bill did clearly remove hemp from the Controlled Substance Act.
And that's the part I'm not saying. I mean, we're talking about the 2014.
Correct.
Now, the 2018 did. What about the 2014? Show me in the text, if you can, where in that 2014 Farm Bill it's removed from the Controlled Substances.
So it was also held in the Hemp Industries Association case in 2018. But the main preamble to the 2014 hemp bill says, notwithstanding federal law, any other statute to the contrary, any other law, hemp is legal in this country. That's what that state did. In the courts, the Hemp Industry Association, DEA 2018 case.
So I just want to make sure I understand now. So you're saying the 2000 Farm Bill said what you just quoted?
That is correct.
And in the text of the statute?
That is correct. The 2014, not the Florida Farm Bill, the federal Farm Bill, the 2000.
And that's the main part of your argument here,
Correct.
that we have preemption. So the text always matters, but the text especially matters here. So you're saying in the text of the 2014 Farm Bill, hemp is excluded and is deemed to be illegal in all 50 states? You're saying it says that?
That is correct. And specifically, again, the statute says notwithstanding any other federal law, the Controlled Substance Act, it says the school policy, it references a bunch of different federal acts that hemp is allowed to be cultivated pursuant to pilot projects. This was also an issue. Yep.
Hold on. That sounds a tad different than it's been legalized in 50 states. I understand the Farm Bill very clearly said that if you're within one of these pilot programs, it has been legalized. But I don't see in the text of the Farm Bill where it legalized it for 50 states. And respectfully, just the opposite. I see at least two references. This is 7 U.S.C. 5940A2, where it talks about whether it is allowed under state law.
So my position is on this, okay? What the federal Farm Bill did was two things. And one of the things that the lower court didn't do in this case is determine the intent of the federal Farm Bill and what that is. We've submitted numerous different documents, articles, the brief of the United States Congress to the 9th District Court of Appeal in the Hemp Industries Association versus DEA case. And in that case, and in the documents that we submitted, it's pretty clear. Number one, it does say notwithstanding any other law. That's first how it gets removed from the Controlled Substance Act and no longer is cannabis as long as it's defined at 0.3%. The provision that you're talking about is specifically the pilot program in that original 2014 bill. What it did was it authorized states to regulate the cultivation of hemp. It doesn't say anything giving the authority of the states to regulate the commercial activity of it at that point. Now in 2015, in addition to the federal Farm Bill, 2015, what does Congress do? In order to further enact the federal Farm Bill and thwart the actions of the DEA and the Department of Justice specifically from interfering with these hemp products, they established 537 and 730-29 of the Omnibus Budget Amendment. Both of those amendments, and this was in the DEA, the Hemp Industries Association versus DEA case, and the KAP case, which was an administrative case by the United States Postal Service, which both recognize that when you read, and just in paramateria, you have to read these statutes together, when you read the Farm Bill consistent with not only the statements of members of Congress, but the budget amendments. The budget amendments specifically state that the Department...
And no offense to any member of Congress. I don't care what the members of Congress say. What I care is what the text says. And their brief, how they describe what they passed matters not, at least to this judge. What matters to me is the text of the Farm Bill. And we're in the Farm Bill itself, in the text of the Farm Bill itself, does it say what you're arguing?
So, two things. Number one, the way it was applied, and where I was going with the two budget amendments, specifically allow and state that the DEA, the Department of Justice, cannot interfere with the shipment of these products throughout the country. So, and my position on the intent is, when we're looking at a preemption argument as argued in Schedule 1, what the court was supposed to do, and I think required to do, is analyze the two different tests and see what that was and whether or not they were required to do so. So, both in the Controlled Substance Act, by them removing it from the Controlled Substance Act, and hemp, cannabis under 0.3% is no longer a controlled substance. It is therefore removed from the Controlled Substance Act completely. Number two, both the Florida statute and the federal statute, and this is where the rub became between the DEA and the U.S. Congress as well, is that they said you can't sell it, you can't ship it. But there was. Both the Florida statute and federal statute are consistent, which they allowed market research. Market research had been held by the courts, by Congress as well. Their intent included the selling and shipment. Realize the initial intent of the Farm Bill.
I fully agree that the 2014 Farm Bill And Florida statute section 1004 allows these pilot programs. I think that's undisputed. I think the state would concede as much. But this is not that. I don't see how your client, I think you've conceded as much. He was not part of this pilot program. So by virtue of him not being within the umbrella of the federal or the state pilot programs, I read the Farm Bill as saying cannabis hemp can still be regulated by the states. And the state of Florida, the sovereign state of Florida, has regulated it in a way that was criminal. So why is that analysis wrong?
So, number one, I do think it is incorrect. Number one is, again, that market research. For one, the Farm Bill only established and permitted states to create programs for the cultivation of hemp, right? So these states could create pilot programs which could determine the cultivation of hemp, but also part of that was market research. And that's why they enacted those budget amendments to say, hey, listen, it doesn't matter where the hemp is grown, it can be shipped anywhere in the country as long as it is cultivated pursuant to one of these pilot programs, pursuant to either, because you can do it. The state does not have to enact any pilot program under the Farm Bill. They could instead apply directly to the United States Department of Agriculture to cultivate. So
Did your client do that?
he did not. And again,
Was he a part of this pilot program?
he is not a cultivator.
Then why would he be entitled to any protections or contemplations of the statute?
Well, and this goes back because number one, it's hemp, and I think they should have had to recognize that. Number two, there is nothing in the statute that deals with commercial activity by vendors at that point in time. Nothing, not making it illegal or legal. And the officer in this case,
Does that leave the state of Florida then free to proceed? If the federal statute silent?
I don't think so. And I cited the Revis case, which was a federal case out of Tennessee, where they had went in and raided a bunch of these shops prior to the 2018 Farm Bill. And this is the thing between the two that are consistent. Florida at that time defined hemp as a different substance. Okay, under the pilot project, whether or not you say, but those issues were directly for cultivation. Our client was not for cultivation. And the biggest inconsistency that we have in this case, the detective in this case admitted that these products were legal since 2015. Now, the issue was, it was hemp flower, and he didn't believe hemp flower was legal. Because realize in this case, the detective came in and seized a bunch of products from my client. They seized hemp gummies, and these are CBD gummies, and the officer in the state in this case is differentiating and saying, CBD is legal, but hemp isn't. But you can't have CBD, and his expert was someone selling these products at a nutritional store, selling hemp CBD products that were created and derived from the same exact federal program that they're now trying to say, this product, and you're not legal to do this, but this guy is. And that's the inconsistency, because they're acknowledging hemp is legal since 2015, but just not the hemp flower.
But doesn't it beg the question? I mean, it sounds like your client was not prosecuted for the CBD products, correct?
Well, I would disagree, because just because it's a CBD product and a hemp flower doesn't mean it's not a CBD product, and that's where the big confusion comes. And we were never permitted to test it. I know they have a different position, and we dropped that, but the judge determined the percentage of THC in this case was irrelevant. Despite the fact that, and realize the detective in this case numerous times testified that CBD hemp products were legal since 2015, and that his expert.
So is the argument, I want to make sure I understand, are you saying there's some sort of judicial estoppel by virtue of that detective saying those things, and that the state is somehow bound, even though he may have been wrong about that?
Well, I mean, they gave the products back to him, both with the state, all the CBD products, they gave back to him. The detective's testimony during this case was, well, I didn't know CBD products could have THC in them. I didn't know CBD products could have flower form. So really, the only time that these products became illegal is when we decided honestly to file a civil suit against them, and then they charged my client a year later with these charges. Up until that point in time, the state had recognized that they weren't sure, and they had decided not to prosecute. So, the detective knew that these hemp and CBD products were legal. I think that they were consistent with the Farm Bill and the Federal Act. We weren't asking in this case, in the 10th Amendment argument that they supplant Florida law, but they just recognized Florida law. The Florida law and the pilot program doesn't define pilot programs as only those programs licensed in Florida. It defines pilot programs licensed to cultivate hemp pursuant to the federal law. And that's exactly where my client was purchasing these products from. And at that point in time, the interstate commerce and these products were being sold throughout the state of Florida.
Does the 2014 Farm Bill overtly, in the text of the Farm Bill, allow you to sell industrial hemp?
I believe it does.
Well, just give me chapter and verse. I want you to read that to me.
It's the provision that deals with market research, Your Honor, and it does say that the entities under the pilot program are permitted to do research, including market research.
Well, and your client is, you just conceded that Judge Sal was not part of the pilot program, correct?
Again, the pilot program applies to cultivators. Like, for example, even today in the
So the
state.
answer is that's correct? Your client was not a part of the pilot program?
That is correct, because he would not be required to be because he was not a cultivator.
So that marketing statement you just read me from the Farm Bill would not apply?
So I disagree with that. What that marketing statement is, it allows the people who are cultivating, who are licensed cultivators, to create products and then sell them and distribute them. There's no limits either in the federal Farm Bill or the state law Farm Bill at that point in time, which limited retailers from selling them. And again, these products were being sold throughout the state of Florida at the time. The detective acknowledged that they were legal since 2015, which is consistent with the 2014 Farm Bill, and the CBD products being legal because of that. So the pilot project is again, it's a cultivation issue. It allows them to create products and then sell them commercially throughout the country. And that's what Mr. Frederick was part of that project, in that he was one of the instrumentalities of interstate commerce in receiving those products and then selling them consistent with the Farm Bill. Now realize the federal Farm Bill, the intent of it was originally to create and determine whether or not there's an economically viable crop in the United States for hemp. They could not do that without allowing and permitting the sales of it. That's why they created the budget amendment to further clarify that the Department of Justice and the DEA could not interfere with interstate shipment of these products. And that's really where I think the intent of this comes out, is because there are some situations, and that's a big reason why they created the 2018 Farm
So you
Bill.
have about 3:15 left.
Sorry, I'll reserve it.
Please, if you want to reserve the rest of the time.
I will.
All right, thank you. For the state of Florida?
Yes, good morning, Your Honor. Your Honor, my name is Dan Caldwell of the Attorney General's Office. I represent the state of Florida appellee in this matter. Our argument is obviously exactly the opposite. It's the state's position that there was nothing in the Federal Pilot Program Act of 2014 that had any impact on Chapter 893 from January through December of 2018. Cannabis was defined as any part of the cannabis plant under Chapter 893 that contained THC. The state was under no duty to prove any particular level of THC. The question was asked whether or not the 2014 Farm Bill specifically authorized, I believe it was essentially couched in terms of, because the Farm Act did not authorize Florida to criminalize hemp, we could not do it. That's not true. We are a separate sovereign. What Congress does, they have, I'm not arguing there's no such thing as preemption or the Commerce Clause. I know that's a thing, but that act is very short. The Federal Act of 2014 is about a paragraph long.
What do you do, counsel, with the argument? This is sort of the gestalt of the argument, as I understand it from the appellant. This product was lawfully sold and purchased in a place other than Florida. Why does that not sanitize it when it's sold here in Florida? What is the state's position on it?
Well, under the record, the states cited where appellant said he bought this was from Colorado and Oregon. So, okay, hemp is legal there, so is cannabis. Cannabis is not legal here. Just because it's legal there, that doesn't mean it can be shipped and sold here. Anybody in Florida is free to go to Colorado or Oregon, buy hemp, use it there, buy cannabis, use it there. It does not mean they can bring hemp back and use it here. Cannabis is still illegal here. And it was actually only a year later that Florida legislature recognized, okay, we're going to pull hemp out of this definition. But that hadn't happened yet. You don't get to say, you know what, I've got a good feeling this is going to be legal a year down the road, so let's start selling it now. The 2014 Act, when referenced by appellant, that it removed hemp from the Controlled Substances Act is not true.
Well, I was going to ask about that. That was not my understanding.
No.
So the state disagrees with that characterization.
Absolutely, Your Honor. The federal pilot program, when you look at just the first paragraph of its, well, basically the entire act is roughly a paragraph, and it references, when it says it removes hemp from the Controlled Substances Act, it references Chapter 21, United States Code, Section 8, or Chapter 801. It does not say anything about states. The state of Florida doesn't have to wait for Congress to say, you know what, it's okay for you guys to make hemp illegal. It was already illegal. It's not been legal in my memory since I've been practicing law, or long before that. So to argue that the 2014 Agricultural Act somehow says that hemp has now been removed from the Controlled Substances Act of all 50 states, it's just not supported. There would have to be express preemption language to that effect. It listed Chapter 21 of the United States Code, so
Is there anything else that's prohibited in the state of Florida as contraband that is not prohibited under the Controlled Substances Act?
anything prohibited under the federal, that prohibited in Florida?
Everything that falls outside the CSA that we prohibited in Florida, restriction.
With reference to the Farm Bill Act, I do not believe so, Your Honor. Only because that was only about hemp. That was a situation where Congress said, listen, there might be a market for this, so here's what we're going to do. States, if you want, and if your law allows for the cultivation of industrial hemp, you may create very carefully regulated pilot programs that are going to be authorized by your State Department of Agriculture, universities, and this will be regulated. Under the Florida statute, any hemp grown in the state has to be authorized by a university. The Department of Agriculture has to know where it is grown. That place has to be subject to certain regulations. There's nothing in the Act or even in the Florida Act to say that a private individual may now sell hemp. An individual selling hemp out of a smoke and vape shop has nothing to do with a qualified project partner or qualified personnel under the Pilot Program Act. In the motion to suppress, the judge went through that statute, the motion to dismiss, the judge went through that statute very, very carefully. No evidence was ever presented that appellant was in any way, shape, or form connected with the 1004 statute. And there's a lot of requirements in that statute that one has to. For example, a qualified project partner means a public or nonprofit entity that has principal place of business in this state. So that doesn't mean that, let's even say for the sake of argument, that the hemp purchased in Oregon and Colorado was part of it.
Counsel, let me ask you this. As you heard, there was a lot from the appellant about the detective and the CBD gummies. Is that a feature of our analysis here, the fact that those were returned to the appellant? He was not arrested for those. Is that an inconsistency here that we need to be able to rationalize or not?
No, Your Honor. The detective's understanding of what the law may or may not be had no bearing on the court, had no bearing on the state. Perhaps if there was a challenge to the search warrant, but that would have been a challenge to incomplete facts. Whatever the detective did or did not believe, what CBD was versus what hemp versus what cannabis was had absolutely no bearing on the court when determining what the state had to prove. A detective's understanding of the law, I'm aware of no authority, and none has been cited, that states that a case agent or a police officer's understanding of the law somehow creates an estoppel on the prosecutor's office.
And that's almost what I'm divining from the argument. Is they're arguing you're stopped somehow by virtue of this detective's legal misunderstanding. Did he have a legal misunderstanding, counsel?
No, Your Honor. And again, there's a lot of information regarding the difference between CBD and hemp, and one can take a deep dive in the internet and find all sorts of information, but that's subject to verification that we don't have here. So I limited myself to the record. In the record, and with all due respect to opposing counsel, he mentioned the word CBD flower many times. CBD, I'll probably mispronounce it, stands for cannabinoids.
Other than the medical marijuana statute, is there any statutory exemption from the definition of cannabis that would have included the CBD gummies or the CBD oils or the CBD shampoos or
Well,
any of that stuff?
I'm sorry, I didn't mean to interrupt. Okay. There is no, it's the plain language of the statute itself, because the plain language of the statute itself says anything that comes from the cannabis plant, I can't remember the Latin name of it, that has THC in it at that time was cannabis. Detective Castrillo testified that he had someone he consulted about CBD. The reason it was initially seized is because it field tested positive with the field test kit. However, when he went and spoke to another individual who he had investigated years before about CBD, he said, what's the problem here? If I send this to FDLE, what's going to happen? He said, you could, but modern CBD is a little bit stronger than the old CBD. It will test positive. On a field test, it will not test positive at FDLE. And that's all the state of Florida had to prove. So when the prosecutor sent the cannabis, because at that point in time, there was no difference between hemp or cannabis, when he sent the cannabis to the FDLE lab, and the FDLE analyst testified, yes, this is cannabis, it has THC in it. If he had done the same with the CBD, the answer would have been no, this is not cannabis, because under our more sensitive and exacting test, besides just the little chemical test you all use in the field, this CBD did not show any THC. So the plain language of the statute itself does exempt CBD. And the detective did the right thing. I am a bit mystified as to why he is being vilified for researching so thoroughly and then returning everything that he knew. Okay, I guess I was wrong. Sorry about that, but I was right about the cannabis. If that answers your honest question.
So, and just to summarize what you just said, counsel, and the record speaks for itself.
Yes, sir.
The CBD component of this was not criminalized, correct?
No, because it would not have tested positive for THC under those standards. So the CBD was not criminalized, hence it was not prosecuted, and those materials were returned. They were not contraband. That was discovered later. Errors happen in law enforcement because, again, the detective testified after the first search warrant, it did test positive, but that's just a presumptive positive. For example, I was a prosecutor for a long time. If I have a case and I'm trying to prove cocaine, I can't rely on the presumptive positive test of cocaine. I have to send that to FDLE, establish chain of custody, and then once I've done that, the FDLE analyst, who I have to qualify to be able to give an opinion under Florida law, has to say, yes, these are the standards, this is what we do, this was blind tested, that substance there is cocaine. If we tried that CBD, that would not have happened. The testimony would have been, no, you wasted your time, that's not contraband. Aside from that, Your Honors, the state's argument is very simple. Just simply that the state of Florida was under no obligation to prove any percentage of THC in this case, and that the appellant was properly convicted in the proceedings below. I don't want to speak just for the joy of hearing my own voice. I actually don't like the sound of my own voice, so unless the court has further questions for me, the state will rest on its brief. Thank you, Mr.
Caldwell. Rebuttal.
Yes, Your Honors. I think that the aspect of the CBD not being criminalized again goes to this whole aspect, and the state attorney's office agreed to give it back. And they're making this distinction between CBD and hemp. Like CBD and those products that they provided back to them would not have been legal other than through this same pilot program in the soon federal farm bill. There's no...
So are you telling us your client should have been arrested for CBD?
No. If they're considering the hemp illegal, the flower illegal, then they should have been required to be consistent and all the CBD be illegal as well, because they were both legalized under the federal farm bill. So for them to differentiate those two different products, and it's like basically, having a hot chocolate and chocolate ice cream, they're both the same thing, they're just in different forms. They're recognizing the authority of the 2014 Farm Bill in allowing these CBD products to be sold throughout the state. but then not recognizing the CBD hemp flower, which is under the same statute and authority. So then he would have, again, the detective and the state then gave him back contraband by their own argument that these products were not legal, but yet this one hemp flower was legal. It's an inconsistency. It's because they did, in fact, recognize the Farm Bill. They didn't recognize how CBD became legal. They just didn't understand why and the authority of it doing so. So I would say...
I'm not sure that's what I heard, so let me clarify. What I heard was that the CBD products would be, under the text of the statute, presumptively illegal, but they can't send it to a lab and prove it. Whereas hemp, also presumptively illegal under the terms of the Florida statute, could be sent to FDLE and proved to be a derivative of cannabis.
So at that point in time, that's entirely inaccurate.
Okay.
Both FDLE at that point in time only tested for the presence of THC as well. So their results would have came back, and this is what we requested the court allow us to do, is get an independent third-party lab test by someone who was actually ISO and accredited to test hemp products that we were denied because it became irrelevant. And that's not actually accurate either as to what happened in this case. What the detective said, he didn't give back the products because they didn't test positive. They all presumptively tested positive for THC. And if they sent them to the FDLE, they probably would have as well. Because this is the big problem, is CBD products, even at that time, were allowed to be full spectrum. And the detective says, during my investigation, I found out that CBD products could have THC in them. That's why he gave back the edibles and things like that were testing high. Because he learned that now, hemp CBD product or CBD products, because he just thought CBD was a molecule, not something derived from hemp, was legal. That's where the big problem becomes. And again, I would state in the, we do state it in the spending bill in Congress, and these are statements that Senator McConnell made, who was the drafter of the federal farm bill. General commercial activity and industrial hemp products may be sold in a state with an agricultural pilot program or among states with agricultural pilot programs, but may not be sold in states where such sale is prohibited. Industrial hemp plants and seeds may not be transported across state lines. That was the DEA's position on it. Senator McConnell basically stated that...
You've exceeded your time, if you would just summarize.
Yes. Senator McConnell said, federal law does not limit the ability to sell lawfully grown hemp products only to states with agricultural pilot programs. It is legal in all 50 states. It just depends where it's grown, which is consistent with our analysis of the Farm Bill and the Florida Farm Bill, that the pilot programs created entities to cultivate those products, and then those people were allowed to then engage in commercial research, just like they were under our Florida pilot program in this country. They did not have to be licensed under that pilot program. Thank you so much, Your Honors.
Thank you. Thank you both. It was well presented on both sides. So if you two could clear out, and then we'll have the next two attorneys for our next case come forward.
I'm actually on the next one as well, Your Honor.
Thank you, Mr. Caldwell. I think we'll see you again shortly.